No, that is a story in itself. The first verdict came in 2001 when the Delhi High Court said that candidates should file affidavits giving details of their criminal background. And we thought our job was done. But then we were told that the Union of India is filing an appeal against the High Court judgment. We were quite surprised. We thought it was a very sensible thing. But the Union of India did file what is called a SLP, Special Leave Petition. And all the political parties became interveners in support of the government. And at that time, our lawyer said that we need a really senior lawyer. And Trilothan said, who is the best senior lawyer? And she said, Fali Nariman, but you can't get him. But credit goes to Trilothan. He kept calling and he located him in Mauritius or somewhere. And he said, okay, I'll do that. So Fali Nariman appeared for us. Actually, Fali Nariman, Kapil Sibal was appearing for the Congress and he was an MP. And there was one more MP. 3 MPs and Fali Nariman was a nominated MP. So 3 members of parliament were appearing in that case. So the Supreme Court agreed with the High Court judgment and said, no, this must be done. And it told the Election Commission to do it within 3 months or 2 months. The Election Commission wrote to the Government of India saying that the most efficacious way of doing this is to amend the conduct of election rules without having to go to Parliament. But the government, the Union of India said, no, no, this is a very complicated matter. Just like the State Bank is saying it will take 4 months, they said it will take more time. You asked the Supreme Court for more time. Election Commission said, we don't need more time. If you need more time, you go. Nobody went. The time for implementation came. The Election Commission implemented it. The day the Election Commission implemented it, I think it was end of June or something. On 7th of July 2002, there was an all-party meeting consisting of 22 political parties. And all of them said that this judgment will not be allowed to be implemented and we will amend the Representation of People Act. And within 7 days or 8 days, 7th of June to 15th of June, a draft bill to amend the Representation of People Act was prepared. So and given to political parties for comments. So we also got a copy of that draft bill. And there were a couple of things which were unconstitutional. So before it could be introduced, the Parliament was adjourned sine die. There was some petrol pump scandal or something. So we thought that nothing will happen till the next session. Then we learned that the cabinet is about to introduce an ordinance. So about 30 people from across the country met the president, who was Abdul Kalam, who had recently been elected. He was considered to be a non-political person. So the meeting was for half an hour, but it lasted for an hour and a half. He took detailed notes because all these 30 people wanted to give a bhashan. They were all civil society, so-called leaders. So he didn't say anything, took notes, and we all came away. And then the ordinance went to him and he returned the ordinance, which we thought was a great thing. That was the first ordinance he returned. But then the next day the government sent it back to him and he had to sign it. So that became law. And the judgment stood nullified. So we went to the Supreme Court again against that amendment in the Representation of People Act. 3 petitions were filed, one of which was by ADR. And then March 2003, the Supreme Court said that the amendment to Representation of People Act was null and void, unconstitutional, and it has attained finality. There shall be no appeal against this. That is how the first case ended after something like 4 or 5 years. And that is what made some of us, at least me, a hardcore kind of anti-political party activist.